Okay, Robert, speaking of secret court orders or secret trials, let's talk about the judgment, which seems to be a secret judgment very much in favor of Project Veritas in the New York Times versus New York Times. In my video yesterday, if you haven't seen it, go watch it. I go through the decision. I didn't get enough into the context of the actual defamation suit itself, time reasons, and also length reasons. The video was already too long. Project Veritas is suing New York Times, Maggie Astor, and Tiffany Hsu, and 5 other John Does for defamation on the basis of 3 articles that they wrote to ultimately discredit Project Veritas when they ran the Ilhan Omar ballot harvesting scandal. New York Times, Maggie Astor says this was a disinformation campaign. The video was deceptively edited. Project Veritas is known for, they didn't use the word fake news, but they used even worse terms like coordinated disinformation campaign. And in relying to support this claim, Maggie Astor cited a study that she misrepresented because it didn't specifically talk to certain issues of the Project Veritas video and didn't use certain terminology that Maggie Astor implied it used. She relied on this study of an article that was published 1 hour, 63 minutes before her article was published. So her article was an eviscerating condemnation of Project Veritas, relying on a study that had been published. Nobody really appreciated it 60 minutes earlier. So the idea was that somehow Maggie Astor managed to read this, 5,000 page article, a 5,000 word article, process it, draft her response, have her response go through the editors of the New York Times before publishing it. And what became quite clear was that other than being, inaccurate of a description of Project Veritas and arguably defamatory, it was a coordinated disinformation campaign in that Maggie Astor was actively, clearly, collaborating with this other entity that published an article 1 hour before hers, so they could both write their articles at the same time. So Project Veritas sued for defamation in Westchester, New York. Very strong anti-SLAPP legislation, which was amended 8 days after the filing of the lawsuit and applied retroactively. And they sought the dismissal on 2 grounds: failure to state a cognizable claim or whatever standard one, and anti-SLAPP. New York Times was invoking anti-SLAPP to say that they were engaged in a constitutionally protected exercise, and the burden should be shifted onto Project Veritas to show that they have a serious state cause of action. And the judge said yes to both and did not have nice things to say about the New York Times, but very few people seem to be reporting on this.
Oh, of course, no doubt. It's a great ruling because in New York Times, I think since New York Times v. Sullivan, 1965, to my knowledge, has not been successfully sued out of the gate. Now, their Second Circuit reversed a decision in favor of Sarah Palin that reinstated a case, but the district court initially denied her right to go forward. And the mistake that a lot of lawyers have made is to sue the New York Times in New York City itself, in the state courts or federal courts there, where I have reason to believe some of the courts are unduly deferential to the New York Times. They sued in Westchester, which was smart, got a state court judge that was fair, and just applied the law. Also, the state court judge made some wonderful statements about the problematic aspects of what's happened with anti-SLAPP law. Anti-SLAPP law was supposed to be to protect little environmental protesters from being sued out of environmental protest by big real estate developers. It's become big media's tool to beat down underfunded people that they effectively lie about. One of the reasons why I took the case for all the Covington kids is that normally they couldn't afford legal counsel to take on those kind of individuals. So it's New York's anti-SLAPP law used to be very limited. They dramatically expanded it right after the election. This judge notes the timing is kind of interesting. He doesn't go into all the detail, but the further detail is a lot of the New York Times and some big institutional media were facing a whole range of libel risks that they wanted the state legislature to make it difficult and scary to be sued upon. And so they got them to pass a law that's about what was supposed to be a law protecting David against Goliath is, as the judge noted, now a powerful tool for Goliath to quash David. But they overcame that, which was great. And full disclosure, I'm one of the lawyers that's on Project Veritas's list to help out in a range of defamation type suits, because James O'Keefe, the founder, has recognized, now he's got like 350 or whatever it is retractions over his career. the highest number of retractions. And people argue about the scope and scale of those retractions.
Yeah,
It's almost impossible to get the media to say they did anything wrong. So in my view, if you get any kind of, if you get a comma corrected, you've made an achievement. If anybody is in this space, as some of us are, you have to beg, scream, yell, hoot, holler. Now, if you sue them like I do, you get a little more attention, but most people don't. And so it's great to go forward with this case. And really what it exposed, what they did a really good job of, is there's about 6 or 7 evidentiary mechanisms to show actual malice, to show that someone's acted in reckless disregard of the truth. And they documented in detail how each of them were applicable here. The big one was the New York Times still disguises its opinion screeds as journalism. There is no journalism at the New York Times. Dave Rubin is right about that. I quit reading it years ago. It's useless. If I want to get the Democratic Party spokesperson, I can just go listen to the Democratic Party spokesperson. I don't have to get it disguised as journalism. But the New York Times lies to the world. And they tell the world, oh, these are not opinion pieces. Our writers never editorialize. They're just detailing facts. And the court pointed out, and then their defense against the Project Veritas case was twofold. One, they admitted their whole story was misleading. They're like, okay, when we said it was deceptive and we said that, we meant the advertising campaign. That isn't what they said, nor is that how that was interpreted. They were lying and this is the great lie they do. They take some little statement that they can call misleading, and they subtly make it seem like the whole thing that they're talking about was misleading when it's not. This is a routine. Our modern day journalists are trained to lie and libel. That's what they're trained to do. Not investigate, not report, not write, lie and libel. Project Veritas is holding them responsible. And now a judge is going to allow the discovery to take place. And I can tell you, there's going to be a lot of fun stuff in there.
It is. Well, I'll state it all up front. I could see, if one wants to call it bias, it was clear the judge was pissed off with the New York Times or is a Project Veritas fan. Because, the one thing he said, that ordinarily anti-SLAPP statutes are to protect the little guy. In this case, it's literally the Goliath protected against the David. And the expression he used in the decision, or the analogy, was the New York Times, the biggest newspaper that's been around since Abraham Lincoln practiced law, which is that's what we would call a pot shot. It's clearly indicating that he either likes Project Veritas or hates the New York Times. And the other,
he just likes underdogs. He's a state court lawyer, so you can get these court lawyers who are tired of big people whacking up. Like, I think it's kind of like the Chauvin trial. I don't think the Chauvin trial judge is a pro-defense judge by nature, but he doesn't like seeing 12 lawyers on the other side with all these private lawyers beating up on this one defense lawyer. He's like, come on. I mean, I think there's some judges who have an instinctual most of them don't. But there are some that have an instinctual defense of the underdog, and that's how I read what he wrote. He's like, I see this for what it is, big people against little people, and the law and you may have got the law to be on your side, but the facts are not on your side. And I think he's also probably sincerely, because this relates to the Silberman dissent. What you're seeing is more and more judges, more and more agitated at what they're seeing in the media, that they're seeing a degree of media co-option and propaganda that is even far beyond what was the case 10 years ago. In my view, it's always been the case at some level. It's just now, what's going to be revealed in discovery here, my guess, is what you noted. This was a coordinated hit between outside organizations and a so-called reporter for the New York Times.
There's no question about it. There's no question they will discover emails between New York Times, Maggie Astor, and whoever wrote that study to plan the release of the article, to probably vet, review it first. And there's no question. And the judge, in all fairness, he says they've made the factual allegations to state a cognizable claim in law on the first one, and on the second aspect, they've stated enough serious allegations to overcome the reversal of the burden of proof. So, and you got to give it to Project Veritas. They have the receipts, I think is the expression, and there's no question they're going to find collusion. The only question is, can they settle this? I mean, I don't know. I think
the only way Project Veritas settles is if the New York Times does a public humiliating apology, and the New York Times won't do it. So so that's going to go forward, but the discovery is going to be really embarrassing, and you wonder whether those reporters keep their jobs depending on what comes out. It's just going to get worse. They're private. These people can't keep their mouths shut. They're like that the Georgia official who failed to properly delete the recording that showed Trump was innocent of the claims being made against him. These folks don't know how to not never in writing, always in cash. They forgot Earl Long's lesson. These young millennials, they yip everywhere, and they can't help themselves. And my guess is there's going to be a huge paper trail in her Twitter commentary, Twitter DMs, other emails, other messages, texts, because what we're going to find, what Project Veritas is going to be able to prove in this case, is that the New York Times, the great lady of journalism, partially owned originally by a family from my hometown, Chattanooga. So I dealt out political battle with them decades ago. Always condescending pricks, but that's another story. But that's just my take on them. Chattanooga Times is very oriented towards the New York Times, owned by the same family for a long time. But what they're going to find is the degree to which the lead reporters at the New York Times are neck deep in political hit jobs as part of political. They might as well be working for the PR firms that are coming after Project Veritas and other targets. And that will be deeply embarrassing to the New York Times, that there is no journalism at the New York Times. They're just the big lie about the New York Times is that there's journalism at the New York Times.
Well, I mean, that's the thing. It's beyond activism. It's beyond activism. It's overt. It's nothing shy of PR, but dishonest PR. And things that I couldn't fit into the vlog yesterday, but I was just going back and looking at tweets at the time. And you have Ilhan Omar relying on these articles to say, oh, look, Project Veritas is lying again. What's new? And in the lawsuit, New York Times says they argued that Project Veritas was libel proof, which was, the 350 retractions, and I've seen some that they put on the wall and say, okay, some are bigger than others. But to qualify the Project Veritas as libel proof, and the justification for why they're libel proof is look at all the mean things Fox News, New York Times, and all the other major media outlets say to them about them. I mean, that is the New York Times trying to write their own fiction and then relying on their own fiction to make it reality. And so the judge says, good. We don't determine truth by polls in the judgment, which was great. He says it's a long list, but that's not how we determine what's true or not. And they're entitled to proceed to discovery. It's going to be amazing.
Huge win. First time, to my knowledge, New York Times has been held responsible out of the gate in over 50 years in New York. They've been held responsible in some other cases, but not New York. So it could be a beginning of the turning of the tide, and this would be a good transition into the Silberman dissent, which we won't talk about too much. But the famous appeals court judge, who was at times thought as a future Supreme Court justice, laid out what he pointed out was that maybe we should re-examine how much big institutions get special protection under the law, given that they're no longer journalistic inquiries, that they're not really acting in the public interest. They're just propagandistic tools, you leveraging their superior power against those that they target often for false information. And what it's really showing, Silberman is assigned to the Conservative Legal Academy to step back and reconsider the scope to which they defer to big media institutions in these kind of cases. And the fact that it came down with one of the biggest cases against the New York Times to ever reach that stage was very significant, I think, of the tide is starting to turn in parts of the judiciary that's no longer going to defer to these big media institutions in the way they have in the past. And they better be careful about their new business model of propagandizing Pravda style and disguising it as investigative, fact-based journalism.
Now, I want to bring this chat up only because I wanted. This is how I thought about describing it in the video, but because I know that I have young people watching the video, I went with vicious circle instead of this. But if I really wanted to say what I thought, it would have been a vicious circle of this. Chances of appeal, and if it goes to appeal, chances of any appellate judges overturning this?
I think it goes straight to discovery. I'm not sure whether they've changed the anti-SLAPP rules in New York to allow a direct appeal. In some states, they allow it. In many states, they don't. It all depends on the state's laws. I didn't think in New York they had a right to it. If you lose, I don't think they have a right to a direct appeal. But I mean, it's going to be hard to reverse it on any fair grounds. You'd have to be obviously political to do so. And that doesn't stop them from doing so, but it would be tough. Also, the same appeals courts in New York have screwed over Trump's attempts to get reversals when he's had stronger arguments about what is and isn't defamation or libel. So it's going to be tough for them to do that in this context. So I think that in all likelihood, it goes now to the discovery stage where the New York Times is at substantial risk. And it may become one of the seminal cases where Project Veritas exposes the scale of the New York Times corruption of journalism as a profession.
All right, now I just want to pull this one up. DSWP. I don't not say it for BitChute reasons. I just try to keep the language relatively clean because I know that I have my kids' friends watch and they talk to me about my videos when I go pick up my kid from school.
Yeah, I mean, Salty Cracker is much more salty on his broadcast. And if anybody wants us to invite him on a future Wednesday weekly guest, so they know what to say in the chat or in the comments below for me to know.
My one of my friends who watches my channel introduced me to Salty Cracker. I can't say that I don't have thoughts that I want to express that way, but it's not self-censorship. It's just I want the message to be heard and not disregarded because of the. Oh, look at the chat now. Chat's gone crazy.
That would be the true Salty Cracker message.